Welcome to the final session, session 6. And the title, working title of this session is James Madison, Father of the Constitution and the Bill of Rights, question mark. That posing of a question suggests that might indeed be a paradox. How can a person be a father of the Constitution and the father of the Bill of Rights? That's quite a parenting going on. But what's paradoxical about this question is perhaps more to do with 20th and 21st century historiography and scholarship, which scholarship is based in the premise that somehow the objective and function and purpose of the Constitution is fundamentally different than the character and nature of the Bill of Rights. After all, the Constitution bestows power, or so the story goes, and the Bill of Rights restrains power or takes power away, or so the story goes. In fact, over the last 40, 50 years, constitutional law textbooks, they come in 2 volumes, not just because there's so many court cases, but rather because one is on powers, the other one's on rights. And you can see it in the curriculum of law schools. That's powers and rights. And under powers you get the powers of Congress, the powers of the presidency, the powers of the judiciary, and then come the restraints. So that the question I'm posing may have more to do with the fact of 20th century, 21st century scholarship than it has to do with actual reality back in those days. But it is, nevertheless, James Madison acquired the title Father of the Constitution because it turns out that he was the last of the living founders. Or put it this way, he was the last to die of the framing generation. He was 5 foot, depending on who you listen to, 5'2", eyes, I guess, not of blue, but barely over 100 pounds, always dressed in black because he thought he was going to die any moment, and outlived everyone. And he acquired the name in many ways. But is there a substantive reason why he should be known as Father of the Constitution? Well, in the answer is, yeah, he was the one who wrote what is known as the vices of the American political system. He wrote that in April in preparation for that 88-day seminar, which was to occur in Philadelphia, in which he summarized what's wrong with the Articles of the Confederation. That is, its vices, its errors, its defects. And what's wrong with it? And he lists the usual problems: encroachments by the states on federal authority, violations of the law of nations, trespass on the states on the rights of each other, want of concert in matters. And he goes on, and he's cranking along there, and he gets to, too many laws, multiplicity of laws. I mean, and back in those days, each state was making too many laws. I mean, imagine that. And then he goes on to say, mutability of the laws. Mutability meaning that a bunch of legislators come in this year, and then next year, new ones come in and they change the laws. So there are too many laws, too many changing laws. But he saves his longest and his most devastating critique for injustice of the laws of the states. And you think, what the heck is he talking about? He's criticizing the Articles of the Confederation and reserves his most severe critique for what goes on within each state. What's going on? And his answer is that each state is passing laws which violate the 3 rights that we've spoken about all day. The right to property, the right to conscience, and the right to govern oneself through political. And this despite a Bill of Rights. So that we need to pay attention to why is that taking place, says Madison. Because if we don't solve that problem at the state level, then everything that we have fought for, everything that we claim to be different and unique and exceptional about is going to be for naught. And his answer is the Articles of Confederation protect the states. That's what's wrong with the Articles of Confederation. Above all else, it protects the injustice of state laws being passed against state citizens. And there's nothing the federal government can do to get involved to end those injustices. And to be quite frank, there's been a number of such instances over the last 200 years which would validate Madison's, particularly when it comes to civil rights, that it's very difficult for the federal government to get involved unless it gets involved rather, shall we say, definitely with a considerable amount of widespread support of the voting public. So what does Madison suggest? He suggests a fundamental revision in the Constitution to correct these defects. And he says, well, what can we do? We can appeal to the public good. Yeah, right. We can appeal to good motives. Yeah, right. So what ought we to do? And in fact, it turns out that what Madison suggests is the Virginia Plan. So to what extent then is Madison the author or father of the Constitution? The answer is to the extent that he outlines what the problems are with the vices, indicates that the Articles of Confederation constitute the problem. He comes up with the solution, which is the Virginia Plan, which is the draft of the first draft for the talking points for the Constitution. Yes, he's the father, and we might call the godfather is Washington, behind the scene, encouraging Madison to go to the root of the matter, to seek out the problem and root it out and provide some solution which is radical, which is what a radish is. It's a root, and so you eradicate it from its root. And I think in that way, then, Madison is the father of the Constitution. And one might say this very fathering of the Constitution is in opposition to a Bill of Rights. Why? Because his claim is that the state governments have parchment rights, Bill of Rights, and they do nothing to stop the difficulties. So that the Constitution is supposed to replace the constitutional structure, separation of powers, checks and balances are supposed to be the solution for what problem? Parchment barriers. So in that regard, one could put together that Madison cannot be the father of the Constitution and the father of the Bill of Rights. Point one. But I'm not going to stop there, obviously, otherwise I've got 25 minutes to go. Right. Well, point number two, to what extent then is it possible to say that Madison is not the father of the Constitution? And the answer is, well, he didn't get everything that he wanted. Well, since when do parents get everything that they want? But there are 2 or 3 areas where he did not get what he wanted at the Constitutional Convention. Thing one, he wanted to reduce the states to a position of, shall we say, negligible clout because they were the ones who were doing the trouble. But he didn't get his way. And how come? Because the states were represented equally in the Senate, and the state legislatures did the electing of the senators, and as a consequence, the Connecticut Compromise, shall we say, greatly compromised Madison's wishes as to what he thought would be the appropriate constitutional answer to the problem. So he didn't get his way with regard to the states. Secondly, he didn't get his way when he wanted to bestow on Congress all the power for which the states were incompetent. And he didn't want to necessarily list the powers, Congress. He wanted to be able to have that broad sweep. He didn't get his way. He didn't get his way with regard to bestowing on Congress a veto power over state laws that, in the opinion of Congress, violated the contract. So there were three areas where he did not get his way, and just raises a question about, well, in three important areas, then he did not, he was not the father of how the Constitution finally ended up. And you could go through, and in fact, you could make a much longer list than that and tote up the number of times Madison lost. He made numerous propositions and sub-propositions and semi-propositions, and you could actually you could actually add up the times that Madison did not win, and then say, well, look, he lost more times than he won. Therefore, how can you possibly call him the father of the Constitution? That's another way of doing it. But I think that second point is not as strong as the first point, namely that in terms of the general idea, the general direction, the identification of the problem. That's the point number one. That Madison is far more father than not father, even though proposition number two, he lost more specific motions than he won. There's a third area where I would think that one needs to reflect on whether Madison is the father of the Constitution. This was a collaborative effort. And that Madison may have, in fact, point number one, introduced and diagnosed the difficulty. But you're talking about the very, very first multiple founding. In the past, Nero, Cato, Moses, Romulus, there's Remus, but that's a little Theseus. But this is where you've got a bunch of people who have to be persuaded. So even if Madison came up with the idea, he still had to persuade. And in that way, then there were a number of founding, quote, as I think an author has mentioned, founding brothers, if not founding fathers. There were certainly a number of people involved. And when we look at ratification, for goodness sake, 1,700 people involved. And as Madison himself said, that the Constitution, until ratified by the people, is mere words. It is the people who breathe life into the document by providing it with consent. And that's what gives life. If we were talking about fathering or parenting or bringing into the world, it was the people through ratification. And Madison is very willing to identify consent of the people as the parental vehicle for what is going on. All right. I still think that he is an influential figure, very influential figure in the unfolding of the constitutional design, with all those little asterisks I've just mentioned. Well, how about father of the Bill of Rights? Well, I certainly think where we started last time with George Washington, once again as the godfather. George Washington is the godfather of the Bill of Rights, in the sense that it forms the completion of the story, not as an alternative tradition to the Constitution, but as a completion, as a prudential and non-dangerous completion to the story of the Constitution. I hereby recommend that Congress make it its top objective. And once again, the author of record, the person who is pushing this, is Madison. So you have this collaboration. I think it would be very interesting to see the collaboration between Madison and Washington on the parenting of the Constitution and the parenting of the Bill of Rights. Obviously, the devil is in the details, but in terms of sitting around and thinking, look, this is what is needed. We need to go to the heart of the question and raise up the Constitution. And now that we have done that, now that the Constitution is passed, we need to be sensible enough to pull on board the consent of the governed. That is, those who love America but don't feel quite comfortable yet. All right, so now, so in that regard, yes, Madison is also the father of the Bill of Rights. But could we not then say that Madison also lost certain things in the first Congress? The answer is yes. And what I would like to just do is to take a look at this, the fate of Madison's proposals. If we take a look at the fate of the proposals, you can see that he starts off with 39, right if you go to the bottom of the, right, you've got 39, and out of the House Select Committee, he gets 36. What gets dropped? His attempt to have the Declaration, the preamble, joined together. All right. What comes out of the House passage of the Bill of Rights? We get 35, which now come down to, which are bundled as 17. Okay, bundle of 17 amendments. The Senate comes down to 28. What does he lose? You can see no state freedom of press, no state trial by jury, no state and equal right of conscience. He loses those. All right, what else does he lose? Well, he loses the first two because in those various states. All right, so what does he land up with? He lands up with 26 out of his 39. So there's in one sense, if you measure, he doesn't exactly lose more than he wins. He wins 2/3. But he doesn't win them all, and he loses on a couple of very important areas. He loses incorporating. They become amendments at the end. And in fact, he also loses where he wanted to do from the very beginning, namely restrict the states. Is he more of a father than a non-father? Yeah. Why? Because he took the lead again. He took the lead, and even though he lost a considerable number, that's not the point that we need to look at. He took the lead. He took the lead in a first Congress that was not interested in dealing with this issue, as hard as it might be for us to grasp. Having with Anthony reading President Reagan's initial remarks about the importance of the Bill of Rights, it might be difficult to believe that people wanted to get on with the business of governing and not go. You know what they thought? And not go back over old ground again. Hasn't that been settled? Isn't it time to move on? But not for Madison. He wanted it to be complete. But what I also want you to take a look at, and we can return to this table, but what I want you to also look at is the way in which certain, we might want to see how these things were bundled. I mean, this just tells you the raw number. It doesn't tell you the qualitative aspect. It tells you the quantitative aspect, but not the qualitative. So if we were to take a look at the box score, no, not that one so much as the Roger and Gordon show. That's it. Now, if we were to take a look at this 17 amendments passed by the House, 12 amendments passed by the Senate, 12 amendments submitted to the states following a Senate and House conference, and then 10 amendments adopted by the states. Article the first is the enumeration. Article the second is the compensation. By the way, that became, you probably know, that became an amendment to the Constitution in the 1990s, right? It was hanging out there all these years, right? But there was no restriction on it in terms of it expiring. But let's look at the third. This is what I want you to look at. Article the third, Congress shall make no law, look at the language, establishing religion, 1, or prohibiting the free exercise thereof, 2, nor shall the rights of conscience be infringed, 3. Right. That's Madison's proposal, which the House Select Committee accepted. Article the fourth, freedom of speech and of the press and of the right of the people to peaceably assemble and of the common good and apply these governments for redress of grievance shall not be infringed. So that in the beginning, press, speech, assembly, religion were not bundled as one. It's separated, right? You got the religion clauses and you had the other clauses as separate. All right, if we go back up in here, what is it? And let's see scroll up just one more, please. Just scroll up. There you go. Just a little bit more. Right, one more, just one more. There you go. 12 amendments passed by the Senate. So this is what is passed by the House. Now, what did the Senate do? So if we come down to number 3, what did the Senate do? The Senate changed Congress shall make no law establishing religion. Changed that to Congress shall make no law establishing articles of faith. Now, the House kept a journal so we can track it. The Senate didn't keep a journal, so we can't track it. All we can do in the Senate is they have minutes, and they summarize. Macaulay has a journal. We can try to track it. We can try to do diaries. But what is interesting is that this happens to be Madison's language, and it means, in effect, no national religion, right? No law establishing, well, actually Madison's original language, national religion, but it keeps that sense. Articles of faith, all mode of worship, all prohibiting the free exercise of religion, now, you see, it's the Senate that does the bundling. And in the process of doing the bundling, freedom of conscience is dropped. And I wish I knew why. I don't know why. If Madison were really, truly, completely the author of the Bill of Rights, the father of the Bill of Rights, right of conscience would be in there. Why? Because conscience is something that Madison thinks is a natural right, an inherent right, and not a right that depends on inheritance, but rather on inherent rather than inherited. And it was Madison at age 25 who put in to the Virginia Bill of Rights, that last feature, that conscience is a natural right. So Madison starts with conscience. Conscience disappears. I think that personally, the Bill of Rights would be stronger with regard to religious freedom if the right of conscience was still in there. But the Senate, in their wisdom, dropped conscience. And I have no idea what establishing articles of faith means, or mode of worship, or prohibiting the free exercise thereof. So what happens is the right of conscience gets folded into free exercise. I think that's the way to look at it. Or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for redress of grievances. So again, it's the Senate that bundles all of these things together in what later became known as the First Amendment. It didn't start off that way. If we now take a look at here, which is the third, this is the role of what the conference committee did. Madison's back on the conference committee. He's on the conference committee. And I think it's Madison. Congress shall make no law respecting the establishment of religion. The establishment of religion comes back in, and it makes its way finally into the First Amendment. So when we read the U.S. Bill of Rights, it has the establishment clauses there. That clause was nearly lost as a result of the Senate. Well, that's one example. So to what extent then is Madison the father of the Bill of Rights? I would say conscience is not there. Madison conscience is extremely important for Madison. He lost that one, but he took the lead. And he took the lead in religion, and he got back there in the conference committee to try to get back that establishment clause. All right. What about, let's come down. And the irony of this one, I think you'll catch this one. If we were to take a look at the 14th article, sometimes known as the 14th Amendment here, of these 17, the 14th Amendment is no state shall infringe the right of trial by jury in criminal cases, nor the right of conscience, that's Madison, see, nor the freedom of speech or of the press. The irony, of course, is that the ultimate 14th Amendment in the 1860s sort of addresses what was going to be originally Madison's 14th Amendment. Pure coincidence. A cheap laugh, but didn't come. All right. Notice what happens. The Senate cuts it. So the Senate not only cuts Madison's conscience from the religion clause, it cuts conscience from applying to the states as well. Conscience is totally gone. All right. What I want to show you in conclusion, I mean, you didn't expect me to answer the question, did you? James Madison, the father. Yeah, the answer is yes. Up to a point, he is the father of the Constitution because he took the lead. Took the lead in terms of seizing the moment as it needed to be done. A Bill of Rights, he seized the moment and pushed it. And he also seized the content. And he showed what needed to be done for various reasons, both conceptually and prudentially. It was once again, in the first Congress, you got 65 people there, plus in the first Congress. Well, you got closer to 100 when you take the 13 states, each with 2 representatives in the Senate, and you've got to have two-thirds consensus. So I would say yes, with an asterisk of collaborative effort. Okay. Now, what I want to do in conclusion is to return to the wow chart and also to introduce a final table to you. I want to remind you that if you want to, and I would encourage you to play around with this, that for example, if you want to take a look at the politics of the Bill of Rights, you click on politics of the Bill of Rights. Then you eliminate that which you do not want. So you go ahead and eliminate what you don't want. And Lisa, I just invite you to choose, just choose something that we're going to look at. So what we're looking at then is documents. Everything here, you'll find 39 rights. Where you've got the little star, that's the U.S. Bill of Rights. So here's the point. Everything that's in the U.S. Bill of Rights is in Madison. You don't need to go outside of Madison's 39 proposals in the end, having done 5 sessions showing you that you have to go outside. Your final session is you don't need to go outside. Isn't that typical scholarship for you? Why the heck did I waste 6 hours of today, you're saying to yourself, right? But that's the nature of scholarship. That you could actually begin with Madison's 39 steps and then just take it from there. The red asterisks then are what's in the Bill of Rights. So if you want to say, well, what did the House Select Committee do? Well, that's what you see in the House Select Committee. So what did the House Select Committee leave out? Life, liberty, property, happiness, ultra abolish government, civil rights. I mean, right? We've been through that. House passage. What did the House passage? See, cut it back down even further. What about Senate passage and House acceptance? Yep. So now you can get down from 39 to 26, and you can track it. Or if you wanted to do some other thing, we just did politics. You could do origins, and remember what the key is. You choose either part 1 or part 2, these one or 2, and then what you do is you eliminate what you don't want. Okay. What I want to end with is what I will call the monster chart. And this is a chart which gives you Madison's 39 and every single document on politics we've talked about. And you can, there it is. And you want to find out that it's linked, so you could just, Lisa, just click on one. And there's the Declaration of Resolves of the First Congress. And you can track it through. You've got, you can type in the word you want. You've got a word search, due process, whatever you want, track to track in. And you then can go back, you can go to the bottom there and you can see where are Madison's ideas coming from? I mean, ultimately, where are they coming from? And the answer is the Virginia and New York ratifying conventions. Does that mean it's political? In part. Does that mean then that Madison is only playing to the electorate? That's what certain scholars have said, that Madison it doesn't have any principle at all. He's flip-flop, and all he's doing is just pandering and just wants to win. Yeah? You could also say that Madison understands that you simply cannot separate principle from politics, and that you need to understand the relationship between the two. So this one, as I say, is the monster, because every single document is listed there relative to each one of the 39 steps. So this shows you both the fate of Madison's proposals as well as where he might get them from. And questions?
Last week I took my class to a courthouse and the judge did a little presentation and he stated that the right to trial by jury is mentioned numerous times in the Constitution. And do you know why that would be the case?
Why the judge would say that?
Well, he said that and he pointed out that it's in the Sixth Amendment.
Yeah.
It's in the body of the Constitution. Why would that be so important? That wasn't a mistake, I'm assuming.
No. From Magna Carta onwards, one of the main traditions, documentary traditions, is trial by jury and due process. Yes, it's in the Sixth Amendment, it's in the Fifth Amendment. Jury in criminal cases it's in the Seventh Amendment. Yes, jury trial is a Magna Carta plus tradition. Yes, and very interestingly, I realize that it's sort of odd or paradoxical to talk about a liberal tradition. And the two words don't necessarily go together. But if you were to listen to President Obama and Eric Holder, they talk about a basic, may not use the word traditional, but say fundamental American values, basic American values. And you think, well, what are we talking about? Time and time again, they will say, like Guantanamo, etc. That is due process of law. And so that there's something in the progressive or the liberal that is very traditional, I mean, very Magna Carta-ish, about a certain basic American value which is found there. You don't find liberals talking much about natural rights, or progressives talking about natural rights. And for the most part, progressives feel uneasy about such things, about natural rights. They will more talk about like human rights or something. And really one of the things that's happened with the rights conversation, and one of the pictures or the diagrams that's on the Bill of Rights website is where Franklin Roosevelt is sitting there with signing up And yeah, you can see him signing up. And it's there, the Bill of Rights. And it's got freedom of speech, freedom of assembly, freedom of religion, freedom of the press. And that, those are the First Amendment. But what he's doing there in 1942 is actually introducing two different freedoms: freedom from want and freedom from fear. And so what has happened to the idea of the Bill of Rights is that something happened during the New Deal where a Bill of Rights is no longer a restraint on government, but rather an invitation from the people to government to do something on their behalf. So you get freedom from want and freedom from fear. By the way, this is the Christie painting, and so freedom of speech, assembly, religion, and then it's doctored up. And if you take a look at I don't know if you put them both together. Yeah, there you go. Yeah, if you put those two together, you can't do that. All right. Well, this one you can see it looks like it's a chair, but it's adapted. She's got a dress on. But I think that's the fundamental shift from liberty to freedom. I mean, sure, it's freedom of assembly, freedom of this, freedom of that, but the language tends to be liberty. And once you start moving into the New Deal, the language tends to be much more freedom.
When you speak of Washington as godfather of the Constitution,
Yeah.
You were saying when he was doing his inaugural address that Madison could have said that. Do we think that Madison was a ghostwriter of some of his works, like his farewell address?
Well, he passed it around for opinion, but I think that ultimately, but my hunch is that Washington listened to people and he let Madison and Hamilton help him out, but he had the capacity to pen it himself and probably did pen it himself. But he took ideas, and why not with those great people around? No, there you go. See, you can see the difference between the two of them. The Christie, Howard Chandler Christie is the author of that one. And on the website, the Constitutional Convention, you have the Christie painting of the signing. He's the Christie girls. This is the Miss Liberty is one of the Christie girls. And he's that famous one. If I were a man, I'd be in the Navy. I'd join the Navy. And he did war bonds for First World War and the Second World War, and was a great portrait. But a bit too risque even for Franklin Roosevelt.
Can you develop that concept you mentioned in answering, I think, the first question, the differentiation between a liberal's tendency to be uncomfortable with natural rights and their choice of verbiage with human rights? Can you develop the implications of that a little bit?
Yeah.
And the motivations for that?
Well, No, there's a very, very good question, and I said it, so I have to defend it. But part of an answer, I will. No, it's good point. Good point. I think what happens with the progressive mind is that we've all, say, like starting with the late 19th century, certainly maybe even a little bit earlier, but certainly by the late 19th century and into the 20th century, haven't we grown beyond appealing to natural law and natural right? Isn't that a whole bunch of natural nonsense? I mean, what is natural? And if nature does speak to us, it doesn't speak in the language of axioms and Newtonian physics and invisible hands on a watch. I mean, for example, I have a watch just like you have a watch, and it's got an hour hand, a minute hand, and a second hand, and probably an invisible hand. And it keeps it going. I mean, how do these things know what to do? And if something goes wrong, you just throw that part away, stick another part in, and it's like clockwork. And Madison talks in terms of orbits and pulling away from the center and that sort of thing. And there's Newtonian physics and systems. And Adam Smith speaks in terms of the system of natural liberty, or the natural system of liberty. And so this appeal to nature, Rousseau appeals to nature, Locke appeals to nature. Nature never lies. Convention lies. Conventions come into existence and fade away. We adopt things, but nature never lies. And there's this part of the Enlightenment is this attraction toward truth, and truth is to be found in nature and the nature of things in physics and geometry and Euclid, etc. Well, I think a fundamental change takes place in the 19th century and into the 20th century, whereas if nature still is a phenomena what we can appeal to, nature is revealed through biology rather than through geometry, or it is revealed through evolution rather than through metaphysics. I'll give you a very, very simple example, because I know this appeals to you. You like examples, right? Very good. Right. I'm not tricking you, okay? And you don't have to answer. Somebody else can. 2 plus 2. Right. 2 plus 2. What for? Oh, come on. 2 plus 2 blank 4. 2 plus 2. Right. How metaphysical? A person who's biological will say 2 plus 2 becomes 4. No, I guess that's not a good example. But it's very, very interesting. It's very clear to me that is 2 is discrete from 2. And if you add 2 to 2, you get a whole new number known as 4. However, if you have 2 with 2, it becomes 4. It's not that, it's an evolution. It's a movement. It's a motion. It's a dynamic rather than a discrete. It's a motion picture rather than a photograph. Okay? Well, if nature speaks in terms of biology, or if nature speaks to us organically, rather than speaking to us geometrically, then we have a different understanding of nature. Because therefore, values evolve. There is no such thing as a value which is eternal or fundamental or foundational. We ask the question, what does the Declaration of Independence mean to us? We want a living declaration. We want a living constitution, so that progressives are more interested in how things evolve, human measures of decency as these understandings evolve through time. That becomes our standard or our measure. The idea that there is a foundation or an is, to be or not to be, whereas for the evolution it is to become or not become. You can't take things out of time. Does that help? I hope. Yeah, well, all right, good. I was hoping I didn't have to continue. But that's what I mean. What are the implications of that? There are no fundamental values. There are evolving values, so that we can comfortably talk about the standards that have been emerging in the world over time. But we cannot talk about, I mean, it's like saying, to talk about geometrically is to talk about, say, like the laws of nature, nature's God. You would want to avoid, if possible, references to the deity. If you are in the evolving track, yeah, exactly. I mean, God is an entity who exists, and I exist because of God's creation, and so that. Put it this way. Sorry, I know I said I didn't have to continue, but I'm going to. One more time. One more time. It's for the metaphysician, truth is something to be discovered. It's there. So therefore, it's our task in life to discover it. That's what it means to learn. For the non-metaphysician, truth is not something that you just simply discover. It's something that you create. Stop it. You're mocking me.
I'm not.
Yes,
I'm
you
not.
are.
No, I just want you to continue.
Oh, you are so. You're only saying that because you mean it. Do we hold these truths to be self-evident? Do we hold these to be true because we hold them, or do we hold these to be true because they're true? Are they true because we hold them, or do we hold them because they're true?
Hold them.
What?
We hold them
Because they're true.
to us.
Oh, you've just given the game away. No, but that's the point. It's not just to us.
We all have our own truth. We all have our own truth.
Well, that is that is the evolving answer. That would not be the traditional metaphysical answer. We hold them because they're true. That's why we hold them. And the other answer is, well, they're true because we hold them. No, and it's a paradox.
There's a difference.
Yes. Yes. Aren't you glad you asked?
I didn't want to misunderstand you.
Oh. You hear that? Do you think he means that?
I'm not sure.
All right.
Well, just when I thought I had learned everything I could possibly learn in a day, I will now never think of 2 + 2 in the same way again. So thank you so much. I know this has been a marathon day for you. So thank you so much, Professor Lloyd, for all you've shared with us today.
And I would be remiss if we didn't thank the folks at the Reagan Library for their hospitality, for the Ashbrook Center for their great maps, and Lisa, and for everybody here. And may the blessings of liberty be upon you and your posterity.
So the museum is open for another hour and a half. And now that you've heard so much about the Bill of Rights and James Madison, and a little bit as well about the godfather of both the Bill of Rights and the Constitution, we invite you. Today is actually the opening day of our exhibition on George Washington's Acts of Congress, which was his personal copy of the Constitution, on which he has handwritten notes next to the powers of the president. So imagine, the person for whom the role was designed and his own personal notes. So that is up in the second half of the museum. I'll be walking up there in a few minutes, and I'm happy to lead anyone. But we have that. You're free to tour any part of the museum that you like, including the Disney exhibit, which will be here until April 30th. Upcoming exhibits we have later this year. We're going to have a Lincoln exhibit after Disney is gone. And I think that'll take us through the summer. So thank you all so much for investing a day of your time. Thank you, Lisa, for your amazing trigger finger and all that you did with the internet. And thank you to our partners at the Ashbrook Center at Ashland.